Hello, Colorado. This is the Colorado Oil and Gas Conservation Commission. It is November 19th, a Thursday afternoon in the year 2020, and we are undertaking the mission change rulemaking. We're focused on the 1200 series, and closing statements will be listened to today. Before we do that, we've opened up the portal, and it looks like we've got 92 participants. So with that, we will initiate this hearing with a roll call. Hearings Manager Larson.
Thank you, Mr. Chair. Commissioner Gibbs.
Here.
Commissioner Gonzalez.
Here.
Commissioner Hackett.
Here.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 7 out of 7 commissioners present.
Excellent. Thanks everybody for joining us this afternoon. We now have a cool 100 participants with us, and we appreciate you all being here. Before we get started with our normal agenda, which will include some calendaring items and then moving into closing statements, I wanted to provide some remarks and perspective to our stakeholders in Colorado. Earlier this week, the Colorado Oil and Gas Conservation Commission had an unfortunate incident where better judgment should have prevailed. Director Murphy and I would like to begin this hearing with remarks addressing this. What happened is to ensure COGCC's new e-filing system was working. We just developed a new e-filing system. Our staff created an internal site for testing and to practice. This site was accidentally shared with our stakeholders. We apologize that some of the names used during this testing were not professional or reflect our values. This unfortunate incident does not reflect upon the quality of work or the values at COGCC. This commission has more than 70 years of experience working with our industry partners in oil and gas operations. We are committed to continue to uphold the oil and gas regulations in a transparent, fair, and legal manner. Director Murphy.
Thank you, Chair, for starting the conversation on this important point. I wanted to reflect that our leadership team has had a conversation about this incident, and the employees involved have also had the issue addressed by their supervisors. Our goal is to align our words with our actions and deliver the highest level of professionalism as we serve the people of Colorado. We apologize for the conduct, as it is not who we are as an agency, as individuals, or as an organization. And it is not consistent with how we strive to carry out our daily mission to regulate oil and gas operations in a fair, open, and transparent manner. We will conduct ourselves in a manner that is fair, open, transparent, and inclusive. And again, we apologize for the insensitivity. With that, Chair, I would turn it back to you.
Thank you, Director Murphy. Any commissioners with comments? Commissioner Gibbs.
Thank you, Commissioner Chair Jeff Robbins and Director Julie Murphy for your comments. I definitely agree that the released emails do not reflect the values of the COGCC, its hardworking employees, the Department of Natural Resources, or the Governor Polis administration. This incident is unfortunate, and it's right to apologize to the public and to our industry partners for the lack of judgment. I do know, however, how much outreach Commissioner Robbins and Director Julie Murphy and other COGCC staff have conducted during this tenure, not only to industry, but to local governments, conservation organizations, communities, and invested Coloradans. And since April 2019, the COGCC has been charged with implementing Senate Bill 181 and learned to adapt to a never seen in our lifetime pandemic. I assure you the Commission and the organization is working objectively. The pace and number of rules we have considered is very unprecedented in the COGCC, but they've been met with staff and the commissions have been working really hard to deliberate in this consideration, careful study, collaboration, and public involvement during this whole process. So with our upcoming vote, our rulemaking finish line is definitely in sight, in very near sight. but we all know how much lies ahead in implementing our past rules and carrying out the tenets of Senate Bill 181. So I'd ask that we admit our mistakes. We also recognize the Herculean task we have undertaken and hard work we have ahead in meeting our new mission of protecting Coloradans' health, welfare, safety, environment, and our wildlife. And that's it, Commissioner.
Thank you, Commissioner Gibbs. And thank you, Colorado, for listening. We are heartfelt in our approach to the work that we're doing. We will be honest and transparent, and we thank you for listening to us, and we look forward to moving forward in a positive light on behalf of all of our stakeholders. Okay, thank you all. With that, Director Murphy, if I could call on you to potentially talk some housekeeping shop in terms of today, tomorrow, and the final things that are ahead of us.
Thank you, Chair. As Commissioner Gibbs' words noted, we are nearing the finish line as it relates to the 800, 900, 1200, as well as 2 through 600 series rules. As we have continued to finalize 8 and 900 rules, and especially the statements of basis and purpose, it has occurred to staff that we haven't provided any really meaningful time for commissioners to review that revised statement of basis and purpose. And as we are not prepared, or as we are unlikely to finish the 1200 series until sometime tomorrow, I would suggest that you commissioners consider revising our timeline a little bit. And my suggestion is that today we go forward and finish the party presentations on the 1200 series as planned. If there is enough time to begin deliberations, we certainly can. If not, we would take those up tomorrow morning at 9 a.m. as scheduled. Staff will be in a position to release finalized 800 and 900 rules, proofread, et cetera, as well as a statement of basis and purpose to the commissioners and to the stakeholders and parties later today so that folks can begin their review of it. And then depending on how and what changes are finalized in the 1200 series tomorrow, we would endeavor to get the revised rules and the statement of basis and purpose out to everybody as quickly as possible. Recognizing that the importance of these documents and the importance that they reflect the work of this commission, I would therefore propose that tomorrow we complete the work and get to a preliminary decision on the 1200 series rules. I would want a little bit of help from AAG Davenport on this, but close the record for 800, 900, 1200, and then reconvene on Monday to take up the final vote on the package of both 2 through 600, including its SPP, and then the 800, 900, 1200, and its respective SPP, and that would be my proposal. So with that.
Thank you. Thank you, Director Murphy. I concur with your proposal. I think that makes sense and gives commissioners time to review the final product. I would note for the record, and I would have you correct me if I'm wrong here, that a vote on Monday would not implicate the planned effective date of January 15th. Is that correct?
My recollection, Chair, is that we continued the rulemakings through November 25th, which would be Wednesday, as that was the last date by which we could submit everything to the Secretary of State and comply with a January 15th effective date. And I got a thumbs up from AAG Davenport, so I feel like I've correctly remembered this.
Very good. Thank you, Director Murphy. Do commissioners have any thoughts, questions, considerations on this slightly revised calendar? Okay, seeing thumbs up. That's what we'll plan on doing then. And AAG Davenport, do you have anything now, or do you want to make sure you remind me to correctly adjourn us later today?
That also, just one point, I think I would like to remind the commission that we have actually closed the record on 8 and 9 already. And so we would presumably be looking to close the record maybe at the end of the day tomorrow on the 12th, depending on how far we get. That's all that I had.
Okay, and then we would tomorrow move to continue both series. They're under two different rulemaking series, so we'll just need to make sure we remember to do that to Monday. Okay, anything else from commissioners for the good of the cause before we turn to closing statements? All right, seeing none, I have the list of closing statements here before me, and time has been allocated amongst parties as they see fit, and we will initiate a closing statement from the Industry Coalition, and they have 14 minutes. So we are bringing them to the fore now.
Good afternoon, Chair. This is Dave Coleman. I'm gonna lead today. I just need to make sure. I know Chelsea Mara is on because she's sharing. Do we have Lindsay Ryder, Mark Matthews, and Kelsey Wazelinski on? I can't see all the pictures.
I am on, Dave.
Yes, I believe we have all of them.
Okay. All right. Well, with that, I will go ahead and get started. So good afternoon, commissioners. Industry will have 3 witnesses today. I will briefly address compensatory mitigation and then address aquatic species. Lindsay Ryder and Kelsey Wazelinski will provide testimony related to variances versus waivers, and Ms. Ryder will also touch on federal government interaction. Regarding compensatory mitigation fees, industry did not address this in our testimony because we found the fee proposal introduced by staff on May 1st based on CPW's recommendations, not preferable, but workable. As you know, the fee structure remained unchanged in the June 19th draft and the October 9th draft. Until yesterday, stakeholders had no idea that the draft rules regarding compensatory mitigation would be subject to change. To drastically change the proposed compensatory mitigation fee amount, indeed potentially almost tripling these fees per acre, so late in the rulemaking process is inappropriate and not in keeping with the requirement in the Colorado Administrative Procedures Acts that stakeholders should have a meaningful opportunity to comment on proposed rules. Because of these last-minute deliberations, there are no doubt unintended consequences to radically altering the fee structure. For example, Commissioner Gonzalez brought up the potential impact on small operators, which have obviously not been contemplated by stakeholders, staff, or the commission. Our recommendation is for you to pass what staff has proposed since the May 1st draft, gather additional information on the compensatory fees and other fees paid by operators, which, as Director Murphy stated earlier, was a goal of this, and if needed, reassess this in a future rulemaking. Before I get into our proposal for aquatic species, I want to make an important clarification. Except for Gold Medal waters, current regulations have no buffers established for species within 1202 C1R and S. So any NSO you establish now for these species will be a new increased buffer. Next slide, Chelsea. This table shows our recommendations related to aquatic species, and it is a hybrid of options B and C discussed yesterday, but will function closely to option C in practice. Gold Medal waters. We have stated from the beginning of this rulemaking that these deserve greater NSO protections and agree with a 500-foot NSO for these, with only a variance option to get within this NSO. Native species and sport fish, that's the RNS. We recommend a 300-foot NSO for these species. As clarified earlier, there is no NSO for these species currently. Implementing a 300-foot NSO will take this from a 0-foot NSO today in regulation to a 300-foot NSO on January 15th, which does support your new mission. Mr. Ackerman yesterday stated he was comfortable with 300 feet, end quote. And our testimony went over why the referenced material in the SPP does not support 500 feet. Establishing a 500-foot NSO would be one gigantic step at a time when many have pointed out potential data and mapping issues. We are fully on board with a buffer zone of 301 to 500 feet that will require added protections. Next slide. I'll get back to that table in a second. These are the red line changes we recommended to implement our recommendations related to the buffer zone. We added Rule 1202A4 to list the requirements an operator must implement if they want to locate a site between 300 and 500 feet from a stream in Q, R, or S. They have to implement all 411A2B protections as BMPs with a little flexibility on the daily inspections if warranted. They have to consult with CPW and implement all additional BMPs deemed necessary by them. CPW would then make a determination on whether the proposed location with the 411A2B and other BMPs discussed during the consultation will protect wildlife resources and whether the COAs are necessary to avoid, minimize, or mitigate adverse impacts as stated in Draft Rule 309E1. Finally, if all of the above justifies it, and only if all of it justifies it, CPW should formalize all of this through the granting of a waiver. Next slide, which is back to our table. While we recommend a 300-foot NSO for RNS, we do believe the current intermittent and ephemeral waiver must be retained for proposed operations within these NSOs. The waiver is critical, even within 300 feet, because of the admitted accuracy issues with the map layers for these streams, which is a reason CPW recommended this waiver. Without a waiver provision, we could find ourselves not able to proceed because the map layer shows an intermittent stream, even though ground truthing shows this is either not an intermittent stream or can't support aquatic species on a sustained basis. The waiver allows for flexibility and was recommended by CPW for just this reason and should be retained. Perennial streams are vastly more accurate and a variance could work for these, but as Ms. Wazelinski will testify, this should not include 2 of the 5 criteria in 502C. Cutthroat trout. We recommend the same NSO, buffer zone, and variance waiver process for cutthroat trout as with native fish and sport fish management. I also want to clarify that this group, as evidenced by Ms. Ryder's earlier testimony, supported keeping this NSO at 300 feet, and we stated that in written responses also. Like other operator groups, we found no evidence that supported the increase to 500 feet, and that was touched on yesterday by Commissioner Gonzalez. This was further supported by Mr. Ackerman's comment that he was comfortable with 300 feet. Lastly, a 300-foot NSO was supported by CPW up to the June 19th draft of the rules. Next slide. This is once again all of the red line proposers needed. Next slide, Chelsea. Thank you. This is once again all of the red line proposals needed to implement our recommendations, which includes adding Q to 309E5D1 waiver provision. I will now turn it over to Lindsay Ryder.
Thank you and good afternoon. First, I'd like to start by saying that CARIS agrees with the proposed buffer, distances, intermediate zones, and the waiver and variance steps Mr. Coleman just presented. We'd like to specifically reiterate that the Commission retain the current 300-foot NSO buffer for cutthroat trout. We presented examples of responsible development that has occurred in consultation with CPW and BLM within the proposed and current 1202C NSO buffers. There have been no adverse impacts to those waterways that would support an increased buffer. The protections that were put in place have been adequate. We do not believe that there is a compelling reason or substantial evidence in the record for the NSOs for native aquatic species, sport fish management waters, or cutthroat trout to be set at 500 feet. Next, I'd like to thank you for considering the consultation and waiver process that we feel would be appropriate in the site-specific scenarios as described in our testimony. While CARIS believes that the variance process should be retained for locations within 300 feet of perennial waters that contain the species listed in Q, R, and S, we have substantial concerns regarding the efficiency of the variance process, And I do think it's worth sharing with you some of Karis's experiences. And unfortunately, the current 502B variance process is not reliable or efficient. In fact, Karis has experienced variance requests that have taken anywhere from 6 months to 5 years to be resolved. The Commission's guidance documents on these variances state that staff have 75 days to approve or deny the request, but this deadline has largely been ignored. I share this with you so you understand that we do not have faith in any type of variance process, and the proposed 502 variance process does not appear to be specifically intended to address a waiver or variance recommended by an expert agency such as CPW. We are more than prepared to make a requisite showing for any variance, waiver, or exception, and Karis will commit to reasonable measures to avoid, minimize, and mitigate any identified impacts. Flexibility, however, is required, in particular when we are talking about wildlife resources. I also understand from our legal counsel that prompt action on permits is required by law. In brief, if we move forward with the variance process as proposed, it is critical for the procedure to be timely and efficient. And lastly, I would like to request that you please consider the federal permitting process. We are not asking you to defer to the federal agency. We are asking that you create a process that allows for coordination and cooperation. The proposed 502 variance process does not do that. And in fact, the 502 variance process as proposed does not allow for concurrent permitting. There is too much uncertainty associated with the variance process to pursue federal permits concurrently. I expect that they will be pursued sequentially, either before or after the Commission has processed a permit, as to avoid the unnecessary expensive resources. We would ask that you please consider the red line provided by Kinder Morgan CO2 and WRLG. CPW and the Commission would be involved in the siting and evaluation of any location on federal lands. And we believe the Commission could benefit from the additional resources that BLM can offer, specifically the resource specialists that are well-versed in evaluating all environmental and wildlife impacts on a cumulative level. Thank you again for your time and consideration.
Good afternoon, Kelsey Wazelinski of Jost Energy Law. I will briefly address the Rule 502C variance criteria should the Commission decide not to adopt a CPW waiver process for Rule 1202C1. We agree with Chair Robbins and Commissioner Gonzalez that any variance considered by the Commission for a 1202C1 buffer should include only 3 of the 5 criteria in Rule 502C, because the relevant question that needs to be resolved is quite different than in a typical variance situation. The 3 criteria identified as relevant here include that the requested variance will not violate the basic intent of the Act, that the granting the variance will result in no net adverse impact to wildlife resources, and that the requested variance contains reasonable conditions of approval or other mitigation measures to avoid, minimize, or mitigate adverse impacts to wildlife resources. We support removing Rule 502C criteria number 1 and number 3 for all 1202C1 variance requests because these 2 criteria are not relevant, reasonable, or necessary to ensure wildlife protection. As to the first criteria, requiring an operator to demonstrate that it has made a good faith effort to comply or is unable to comply with the specific requirements contained in the rule is not relevant when seeking a 1202C1 variance with CPW support. On its face, this requirement could be interpreted as requiring an operator to demonstrate that there are no feasible operational locations outside the buffer area, and it must therefore operate within the buffer. But that shouldn't be the relevant question. Instead, an operator that proposes development within a 1202C1 buffer must demonstrate to the satisfaction of CPW and the Commission that the operator's proposed mitigation measures, habitat improvement conditions, or development timing restrictions will avoid, minimize, or mitigate adverse impacts to wildlife resources, result in no net adverse impact, and not violate the basic intent of the Act. Whether or not the operator could technically establish operations outside the buffer should not be relevant. As to the third criteria, requiring an operator to demonstrate that its requested variance is necessary to avoid an undue hardship is also not reasonable, necessary, or relevant in this context. If CPW and the Commission agree that the proposed location and mitigation measures will avoid, minimize, or mitigate adverse impacts and will result in no net adverse impact, then whether undue hardship will be caused if the variance is not granted is irrelevant and will be a difficult, if not impossible, standard to adjudicate before the commission. Next slide, please. In summary, including considerations of criteria number 1 and number 3 for a 1202C1 variance will result in much more protected administrative litigation that focuses on the irrelevant issues of whether an operator could technically operate outside the buffer, regardless of whether that location is more protective, and whether operating outside the buffer will cause the operator undue hardship. We propose that a new subsection 3 be added to 1202C as shown on this slide to set the applicable 502C variance standard. This concludes the industry group closing response, and we are happy to take questions.
Thank you, and thank you for closing the screen share. Do commissioners have questions? Commissioner McGowan beat you by a hair, Commissioner Gonzalez.
Thank you, Mr. Chair. Thanks for your thoughtful feedback on our painful discussion yesterday. Much appreciated. I have two questions. One is, I think in my mind, asking for a waiver or a variance would be related to being unable to comply with the rules as they stand, right? Like, wouldn't that be the reason that you're asking for a waiver or a variance? There must be a reason that you want to be within the buffer and that you're unable to be outside the buffer versus just wanting to be inside the buffer. But maybe I'm misunderstanding, and I'm wondering if you could expand upon that a little bit, Ms. Weslinski.
Sure, I'm happy to take that question, and it's a good question, Commissioner McGowan. The issue here is protection of wildlife. And so technically, if you're proposing a location, you may run through an alternative location analysis. There may be a location that is within a buffer. There could be alternatives outside of the buffer. But through consultation with CPW, it's determined that operating within the buffer is as protective or maybe more protective. And I think that's a very site-specific consideration. And so in that context, proving that technically you could operate outside the buffer may not be the right question to ask, especially if you have CPW support. So that's why we're requesting that that criteria be removed if you're requesting a variance from 1202C1.
Follow-up, Commissioner McGowan.
Thank you, Mr. Chair. So does the no net adverse impact rule then help address the I'm unable to comply? And sorry, do you see what I'm saying? Like, so even though you might be in the buffer, the no net inverse impact, would that help assure protection within the buffer in this variance request? Sorry, I just need to understand.
Ms. Weslinski.
Yes. Thank you. Yes, it would. We think that's the relevant question to ask. Will there be no net adverse impact in addition to the other two criteria? That's really the standard these should be held to, because there may be an instance where technically you could operate outside the buffer, but for a multitude of reasons, it's preferable or equally protective to be within the buffer as long as you don't have a net adverse impact. So really we're honing in on what questions are relevant when you're seeking to operate in any one of these buffers. And obviously that's through consultation on the ground with CPW, and they would support that request.
Okay, thank you. And then under the scenario for the buffers and the waivers, I assume that CPW could still, after consultation, recommend denying the waiver or deny the waiver, I guess, because the waiver is actually CPW's decision. That option is still available?
Yes, Commissioner, it is. If they feel it's not protective under this scenario we've laid out within the 500 feet, then yeah, they could recommend denial for sure.
Commissioner McGowan.
Sorry, and now I have a question too. I think a conversation that's going to come up later today. I would like to know if the requirements that we've been talking about for the intermediate buffer zone in 411, I don't know how to word this, so I'm just going to say it the way that I'm thinking about it, but it's not the right way to word it. Are those with the exception of, I understand in some of these instances, a daily visit might be difficult depending on geography and where something is located. I feel like the other requirements are pretty kind of common sense for an operation, a new operation that would exist somewhere. And I would like to know how onerous those requirements are.
Mr. Coleman.
I could take this a little bit, and then Ms. Wozzelinski did a lot with this in 411, so please chime in. Industry had a very good conversation during the 400 series on these exact requirements and came to some consensus with the public water supply systems. So, I mean, yeah, they have some level of onerous to them for sure, but we were able to come to some agreement within the 411 rules on what those mean. I'll leave it at that and see if Ms. Wozzelinski, if you want to add anything to it.
Sure. At this stage, I can't represent what our clients think about that just because they haven't considered this proposal yet. But I will say that the intermediate buffer zones in Rule 411, especially when you're operating near a water body, are fairly, I don't want to say standard, but they're good operating practices. Things like spill containment and berming and pitless drilling. Yes, I think we need to talk about the inspection requirement, but I think especially if you're operating near a water body, these are things that are typically done. I can't speak for my clients, but that's my personal position.
Ms. McGowan.
Thank you, Mr. Chair. Sorry, last question. So if I'm coming at this from a perspective, I'm trying to be more protective of the water, and you all are arguing that buffer needs to be smaller because there was no buffer before in some instances. Wondering how you would feel expanding the zone where those 411 requirements would be required if we move that buffer in. The trade-off being that folks want to make sure that from a further distance you're still implementing those best practices and minimizing the chance of spill into these precious waters.
Mr. Coleman.
Thanks, Commissioner. I think industry is very willing to have that conversation, Commissioner. We had it in the 400 series, and we're definitely willing to have that conversation on whether those 500-foot numbers that we threw out there in my presentation need to go higher. Definitely willing to have that conversation.
Commissioner Gonzalez.
Thank you, Mr. Chair. I had a couple questions. The first one, I'll stick with kind of the conversation that's been going on from Commissioner McGowan's questions. And is the variance the adapted language that you're suggesting for 1202C3, kind of with those two, two limiting factors, I guess, for the variance? Is that to be applied for variances that are sought within 300 feet of these waters? Or is that an alternative that's being proposed should the waiver and intermediate buffer set up as an alternative to that?
I'm happy to take the first part of that.
Please do, Ms. Wozzelinski.
Thank you. I'll let Dave comment as well. Our goal with this is that any variance that's applied for a 1202C1 buffer would only incorporate 3 out of the 5 criteria. So we can talk about when the variance would apply, but our thought is if a 1202C1 variance is being sought, especially when you have CPW support, that 2 of the 5 criteria just simply aren't relevant. So it would apply in all instances when a variance is sought. And I'll maybe let Dave dovetail on that.
Mr. Coleman.
Thank you, Chair. Yes, Commissioner, I think the vision is if there are circumstances, which I suspect would not be many, but if there were, when we needed to, or felt we could be protective within the NSOs, the 300-foot for the QRNS or the 500-foot for gold medal waters, that would be a variance, and that the variance criteria of 2, 4, and 5 would apply. Still a very high bar to cross for sure, but that is what our proposal contemplates.
Thank you. My next question is for, I guess it's for Ms. Ryder. I'd like to hear some more details about these variances that are taking 6 months or 5 years. What's what's the holdup? Are those parties continuing the variance, or is that actual, evaluation that's being done by staff? What I'm getting at is that actual like variance review, or is that procedural delays?
Thank you for the question, Commissioner. Yeah, the variances that we've submitted are really specific to final reclamation landowner variance requests. So the majority of these variances that we've seen the larger delays on came from a landowner who was requesting after plugging and abandoning that an access road was left, or a flat area was left for them to utilize for equipment storage, or building a barn, so on and so forth. They have many reasons. And the hangup appears to be in the staff evaluation of whether they agree with the landowner's desires or not. That is the delay.
Okay. And then my last question, or what I think is my last question, is why doesn't the variance process work with federal permits? I think that was a comment that came up in this discussion. I know it came up in Kinder Morgan's testimony. So
yes, can I please take that question? I think that the concern is that if we go through the federal permitting process and we permit a location where the resource management plan for that area allows for an exception, waiver, or modification. So let's say that their resource management plan allowed for that waiver within an NSO that's now designated by COGCC, and BLM approved it because it's validated and allowed under their resource management plan. We would then use their process. We would want to use their evaluation and provide that during the variance process. But if we just simply can't get the variance process from COGCC, it almost seems like a waste of our efforts to engage BLM.
thank you.
Commissioner Messner?
Thank you, Mr. Chair. To follow up on Commissioner Gonzalez's question there, because I'm still not following. So my understanding is in the 300 series, in the 502 variance, there's consistent language. There's been language put in the statement of basis and purpose. There's been testimony given here by staff and by commissioners that, there will be communication and coordination with federal agencies. And what I'm hearing you say is that there's not a way to work with the federal agencies through the variance process. And I guess I'm not understanding why.
Ms. Ryder?
Yeah, yes, I was trying to think about a good answer there. I think the concern is just that if we felt like we needed to get to the commissioner hearing before we would be allowed to, for example, we're in a sage grouse NSO, 1 mile NSO, but because of the local terrain features, BLM would approve us to be within that 1 mile NSO. But because we have a strict NSO under COGCC's requirement, we wouldn't be comfortable necessarily like going to BLM and having them say, yep, we're comfortable with the 1 mile, you operating within the 1 mile for all of our reasons, and we are going to allow you to proceed. CPW, they're there and they concur. I think the fear is that we then go to the COGCC process and maybe someone on the commission or in the staff disagrees with BLM's evaluation of whether that variance or exception or waiver is valid or not. And I think that's the concern, is that we would we would already have gone through the process with BLM, and then we would go all the way through it with COGCC, and there would be a difference of opinion.
But I mean, you do realize that whether it's a waiver or a variance, that the final decision making on any of these lies in the commission's hands, 5 different commissioners. And so one commissioner wouldn't make a difference one way or the other. But whether it's a variance or whether it's a waiver, the commission will still make a final determination on this. And so, I mean, I appreciate the concern. I understand that there's certainty that's wanted to be developed. That's why in the past I've talked about, having some of this decision making before the process versus at the end of the process. But I mean, what I've heard from industry, at least in testimony previous to this, is they're okay with the uncertainty as long as there's a waiver process, but they're not okay with the uncertainty if it's a, variance process. And so this is what I'm trying to understand.
I think that our desire is just to make it as efficient as possible. And if there's an opportunity to utilize BLM's evaluation and then bring that to the table at COGCC, that is our desired outcome.
Okay,
And
thank you.
Yes, thank you.
Commissioner McGowan.
Thank you, Mr. Chair. So sorry, I feel like things are getting a little convoluted and I just need to clarify for my brain what I think we're asking for. So based on what you presented today, for aquatic species, for gold medal, sorry, for aquatic species, we're still supportive of the waiver process. We, meaning you, sorry, you all are still supportive of the waiver process. You would like the waiver process expanded to all the species in the 1202C section. If not, your proposal is the variance without the 1 and the 3. Do I have this straight?
Mr. Coleman.
Could we share that slide again? That might help. Thank you, Commissioner, for the clarification. So yes, for the variance versus waiver, what we're saying is for intermittent streams and ephemeral streams, waters, for RS and then expand it to Q from what it currently is now, allow us to have a waiver from any moment of that for intermittent and ephemerals, whether that's within the 300 feet all the way out to 500 feet. For intermittent and ephemeral, you would need to get a waiver. If it is a perennial water within 300 feet of Q, R, or S, we're saying a waiver is not sufficient. You should then have to go through the additional hurdles of a variance. And the reason we're treating intermittent and ephemeral waters different, allowing us to get a waiver when within 300 feet, is just because of the data accuracy issues within those, the mapping issues, the fact that CPW supported it. So we just want to expand that from what it's currently in the rules for RNS to treat it the same with Q, because it makes sense to treat all intermittent and ephemeral waters the same, which is what that change would do. But anytime you want to get it within 300 feet of a perennial water, the variance kicks in. And then for gold medal waters, what we're saying is no waiver provision. It has to be the variance provision for the gold medal waters.
Mr. Chair.
Yes, please.
Thank you. And then for the waiver for the intermittent or ephemeral, are you all supportive of the 411 BMPs?
Yep.
Mr. Coleman.
Okay.
Absolutely, Commissioner, we are.
Thank you.
Commissioner Nanjappa.
Thank you, Mr. Chair, and thank you all for your comments and thoughtful testimony. Appreciate the answers to the questions previously too. So are you also, in what you've put up here in the slide, recommending that we separate out the gold medal waters as a separate category? And then I'm curious as to, given that it was originally nested within sport fish, and we've had some discussions about the cutthroat trout being sort of in headwater streams, what's your distinction between those?
Mr. Coleman.
Thank you, Commissioner. On the first question, yes, you would have to break gold medal waters out from the sport fish and make it its own layer, and then apply the 500-foot buffer on there. The second question, I guess I might need a little more clarification, Commissioner. You're talking about some of the discussion that went around yesterday with CPW?
Yeah, thank you, Mr. Coleman. So currently gold medal waters are included within the sport fish management waters in S. So in separating them out, it seems as though you're making a bit of it, and especially with what you've provided here in terms of the different provisions that you're requesting, you're making a distinction between the gold medal waters and, other sport fish management waters, but also the cutthroat trout. And given, that the cutthroat trout, we're talking about our Colorado native species, our headwater streams, I just wanted to better understand why those would be given additional, or maybe another way of saying it would be sort of less protection than what you're suggesting for gold medal waters.
Mr. Coleman.
Commissioner, I think the gold medal waters is how I understand them and how it's been portrayed, is that they are, for lack of a better term, the cream of the crop waters. So those seem to require additional protections. And the cutthroat trout, I think it is true, and based on the conversation, there could be some streams within the cutthroat trout of Q that may not elevate quite to the gold medal waters and have the 500-foot buffer, but it might be close, but not quite there. And you're right, those would stay within the cutthroat trout Q, which would, under our proposal, have a lower NSO. And I acknowledge that, but I think where that can be addressed is in the consultation. So in those instances where CPW is like, hey, operator, you want to do this near one of these waters that's almost gold medal waters, but not quite. Yeah, we understand it's a 300-foot buffer, but we got a little more we need from you. And as I said earlier, if they can't get there on a site-specific basis, they can say through the consultation and process and waiver process, say no, we're not going to approve this because of that. So that process allows them to address those situations, Commissioner, that I think you're bringing up here with that question.
Commissioner Najapa.
Thank you. That's all I had.
Yeah, I guess respectfully, Mr. Coleman, I think if you're looking at it from a pristine of the water piece, the cutthroat waters are more pristine and more necessary for protection than even the gold medal. I mean, as an example, the gold medal waters that are in my neighborhood is the Animas River, and it was unpristine for a long time as a result of a bunch of old mining that took place. And so if we're looking at it from a pristinity perspective, I would advocate that they should both get the same. But that's just one commissioner, and I appreciate your commentary on that. Any other questions? Did you want to speak to my comment, Mr. Coleman? I didn't mean to cut you off.
No, Commissioner, I just said thank you for the information.
Okay, great. I'm not seeing further questions, so we thank this panel for their closing statement, and we will now turn to our next panel, which I believe is Adams County. Let's give us all some time to replace our panelist. Good afternoon, Ms. Fitch and Mr. Dean.
Good afternoon, commissioners. Greg is going to be handling most of our closing statement today, so I will pass that over to him.
Thank you, Ms. Fitch. Good afternoon, commissioners. This is Greg Dean, Adams County Oil and Gas Liaison. We don't have any slides to share today, and we'll only be giving a brief closing statement. But first, as this arduous rulemaking process ends, I want to levy immense gratitude on its commission, Director Murphy and staff, other parties and stakeholders who contributed meaningfully to this process. There were many unique viewpoints and positions presented throughout this rulemaking, and while parties did not always agree on all topics, this inclusive process has ultimately led to the development of a protective, reasonable, and thorough set of rules that the state and its residents can be proud of. Specifically for the 1200 series, the county is largely supportive of the most recent draft rules. We again acknowledge CPW is the state agency with immense and expansive expertise on wildlife protections and the mitigation and avoidance of those impacts. As such, the county takes no position on many of the technical proposals under consideration, including the delineation of riparian or wildlife setbacks and buffers, the determination of specific species for high priority habitat classification, or the appropriate monetary assessment for mitigation fees or compensatory mitigation. The county's remaining concerns surround process within the rules. We would again like to respectfully request reference in the rules and/or the forthcoming revised draft statement of basis and purpose that explicitly acknowledges local government consultation under the co-equal regulatory framework devised in and further explained under the 300 series. The county is simply asking for a seat at the table during the determination of potential wildlife impacts and associated mitigation measures that would allow local governments the ability to work out any issues or concerns alongside the COGCC, CPW, and operators early in the process. Further, we believe should CPW make recommendations as part of the required consultation with COGCC or operators that could have any land use or surface impact implications, that the COGCC would immediately consult with the relevant local government before adopting any of those recommendations or adding BMPs or COAs to the application. As many of these measures could impact local land use authority or decision-making, including access to the facility and compatibility with surrounding areas, as examples, our involvement is reasonable and necessary. The county acknowledges under Senate Bill 1921 that we have the authority to adopt our own rules associated with consultation requirements and wildlife impacts, but simply make our request in a good faith effort to reduce the occurrence of conflicting decisions between agencies and to be mindful of valuable personnel and time resources. The county ultimately shares in the goals and intentions of these rules to avoid, reduce, and mitigate wildlife impacts associated with oil and gas development, and has complete faith in CPW for evaluating and assessing those impacts within the confines of the Commission's rules. Thank you again for this opportunity to provide feedback on these proposed rules and for your considerations of the county's request. That concludes our closing statement.
Thank you, Mr. Dean. Thank you, Ms. Fitch. Are there questions, Commissioner Nanjapa?
Thank you very much, Mr. Dean. Appreciate the comments. And just a very brief question. Given that the relevant local governments are noticed and involved in the OGDP and therefore in the final decision, and given that you have the ability to request additional COAs or BMPs, per your own rules, I'm just trying to understand what this additional consultation adds, or is it more of a timing matter?
Yeah, thank you for the question, Commissioner Nanjapa. I think that's exactly correct. So the county will be likely going through a revision of our own regulations after the conclusion of this rulemaking, and we'll have to seek clarification from our Board of County Commissioners about whether we want sequential or concurrent permitting built into our own county regulations. And so there's a timing issue there, whether if we decide to go sequential permitting, if the county goes first and then the CPW consultation occurs during the COGCC process, how would that impact a potential permit decision that's already been rendered by Adams County? Again, we have the intention of including CPW in our process as well once we revise our regulations. But we just want to make sure that, and maybe it's just a statement in the statement of basis and purpose, that should CPW consult with Adams County during the Adams County process, that those determinations can be transferred or serve as a partial or complete fulfillment of the CPW consultation requirement under COGCC rules. Again, just to eliminate duplicative processes or conflicting processes. The biggest concern we see potentially happening is along with access roads. So if CPW recommends moving an access road, that's done as part of our pad approval process. So if CPW decides they want to move an access road or reorient the production facility that we've already approved, that would be a major amendment, which would require a completely new permit process under Adams County. So we just want to, while we can, get rid of those conflicting or duplicative processes.
Other questions? Okay. Thank you both for your involvement with us over the course of these last several months. It's been very helpful.
Thank you.
We will now turn to the affiliated local government group. Ms. Larson or Ms. There's Kate Burke.
Yeah, okay, here I am. And I'm gonna share my screen. Okay. All right, and Mr. Hurd is here too, I saw. Okay, good afternoon. Kate Burke, Boulder County Attorney's Office, on behalf of the ALGC and Gunnison County. I have 3 quick points to make, and then we'll get to the main part of our presentation, which is about compensatory mitigation fees. And then I'll bring in our witness, David Hurd. So first, variance versus waiver. We strongly agree with the staff that the existing Rule 502 variance process is the way to go throughout for those reasons that I won't read to you. Second, this photo pretty much says it all. We didn't hear any discussion on this discrete point, but it's so simple and clear and obtainable that we're hoping it was just forgotten in the shuffle. So we're just refreshing your memories that we really request this amendment, simple amendment to 1202A5 to prevent the kinds of damages that Ms. Glowacki talked about and this photo demonstrates. And then we are very much in support of the idea of the Biological Resources Working Group, and we would love to participate in that. So we're just saying, yes, go for that, and we'd be happy to be part of it. We have a lot of experience on our multiple governmental staffs. Okay, on the main subject, compensatory mitigation fees. This is kind of a crowded slide, but I'll let you peruse it while I talk for a minute. We are urging a per acre fee and a higher number than was offered. And based on our experience and our staff expertise, we have 3 main responses here. First, there's virtually no such thing as short-term mitigation or restoration, and all should be considered long-term. Secondly, the new wells and pads and facilities in the Front Range are much larger than the range used by CPW in its averaging methodology, and here in bold are some recent pads in our general vicinity. The per acre cost to protect properties with conservation easement rights are much higher on the Front Range. 20,000 an acre is pretty standard in Boulder County and can be much higher as you approach the boundaries of municipalities. And so we recommend revising those numbers. And 2 ideas we had, first of all, to create regional averages, and secondly, to look at the IRS formula, which is really how CEs are valued and how they're supposed to be valued, period. So that might be a helpful place to go. So to talk further about what habitat restoration requires and looks like on the ground, I present David Hurt from Boulder County Parks and Open Space.
Good afternoon, Commissioners. David Hurt, Senior Plant Ecologist with Boulder County Parks and Open Space. I've been involved with restoration work for approximately 20 years as part of my job here in a variety of grasslands, forests, wetlands, and streams. I was invited here to discuss reclamation and restoration and the short-term and long-term efforts. Proper restoration is difficult work, and in my experience, I've seen a lot more failures than I see success. I'll be honest, some of those failures are mine. But the success is often the result of upfront planning and proper implementation. But even more so, it's due to long-term commitments, years of time, sometimes a decade or more. And even then, you know, we have plots on the ground that show we have not come close to emulating a diverse native functioning grassland that may support wildlife like it did pre-disturbance. And there's a cost associated with all that long-term effort as well. The disturbance of soil structure is difficult to remedy, and good topsoil handling, separation, reapplication, soil prep is paramount. And often this doesn't happen as it should. We know folks may have the best intentions, but the truth is to maintain efficiency of the operation and adhere to timelines and budgets, work doesn't always stop when soils are wet. Seeding doesn't always happen in the most opportune window for successful germination and establishment. We may miss spraying or mowing weeds before they go to seed and compound the problem. These ongoing commitments often require reseeding maybe once, twice, 3 times, and doing it at the proper time and hoping the weather cooperates. Sometimes returning to an area years later to seed again to add some of that much needed diversity into the system. And I'll say this has all been further complicated in my experience and others by a hotter and drier climate that's leading to more and more failures of seeding projects. Weed control is perhaps the task that extends furthest beyond the original disturbance and reclamation. It's well documented that invasive weeds are detrimental to wildlife. They reduce available forage, they outcompete native forbs that benefit pollinators, which is an often overlooked wildlife, but an important group of species. We have multiple studies in areas treated for weeds, cheatgrass in particular, that show a large increase in pollinators compared to infested sites. Studies that show dramatic increases in the growth of native shrubs in treated areas and numbers of grassland birds. So all this to say that getting it right the first time and making that staffing and financial commitment to ongoing work is the least we can do to ensure success in the long term. Thanks. Thank you.
Thank you, Mr. Hurt. Thank you, Ms. Burke. Are there questions for this panel? Commissioner McGowan.
Thank you, Mr. Chair. In regards to the compensatory mitigation, I'm not sure I understood the IRS formula, and I don't know if you could talk about that a little more. But secondly, I think the idea of a regional average is intriguing, but I also think that it can create some inequities where just because you have a region where the acreage is less expensive, I guess I'll use that term. Are you encouraging then growth in the industry in certain parts of the state versus others because of what you might charge for a mitigation fee in one area versus another?
Yeah, I'll speak to that a little bit. So I guess I'll preface by saying the second of your points is, I think there's discussion to be had about the use of conservation easement values to fill in for the mitigation fee. I think the connection between those two is attenuated at best. What a conservation easement is supposed to cost, and this will take me back to the IRS thing, that a conservation easement is supposed to be basically the value of the development rights, because that's what you're buying. You're taking away the right to develop a property. And conservation easements they're basically a tax vehicle. That's why they exist. And the seller gets tax breaks, and they're, of course, their purpose is to protect land, but their structure is all around tax credits. And so they're actually governed by the IRS. And IRS, excuse me, let me find the right, I have the citation if you'd like it. It is Treasury Regulation Section 1.170A-14 That is the IRS code section that discusses the valuation of conservation easements. And basically the way it works is you appraise the property, and then you have an appraisal of the property with development rights and the appraisal of the property without development rights. And the difference between those is what the conservation easement is worth. So that's why, if you really think about that and connect that to compensatory mitigation, it's kind of an odd bedfellow, but since that's where you're headed, I didn't want to upset the entire apple cart. But this is, we had previously recommended that appraisal of the property would be a good place to start. And if you're going to look to conservation easements, they are based on appraisals. And there's an IRS guidance document for conservation easements in general. And I'm just going to read you one sentence from that. It says, each conservation easement must be valued before and after the granting of the easement based on the particular facts and circumstances of that property, and the value must be substantiated with a qualified appraisal. That's how they work. And so if that's the animal you're going to look to create a mitigation fee, that is how they work. And then as far as incentives for different parts of the state, first of all, I think I would guess that operators are looking more for where the mineral rights are rather than where the conservation easement costs are. But I think we're pushing for per acre, because a range from giving the same fee for 1 to 11 acres in size just misses so much actual detail. And the same would be true to say it's $5,000 per acre across the state, when that's just simply not true of what to do the act. If what you're going to do is purchase conservation easement rights as compensation, you're going to pay a lot more than that in many parts of the state. So it's a tricky wicket, so to speak, but since that's where you are, I just wanted to point out some of the nuances in there.
Thank you, Ms. Burke. Commissioner Messner.
Thank you, Mr. Chair. And thank you for the presentation. I think I'm missing some things here. And so hopefully I can get some clarity. I mean, Mr. Hurt, I appreciate the presentation, but it seemed like you were focusing much of your testimony on reclamation versus, you know, more of a compensatory mitigation type of approach. And so I guess I was unsure of how these two things tied together. Whereas the compensatory mitigation and the projects for habitat improvements or other projects that would mitigate the impacts of an oil and gas location is kind of what we're considering here versus the reclamation process, which is totally separate. So maybe you can help me with that one.
Mr. Hurt.
Sure, thanks. I was just trying to address, as Kate pointed out, the difference between maybe the short-term compensatory requirements versus long-term, and that that it should be considered, all these sites should be considered long-term, because that's really what it would take.
Okay, that makes sense then. So I understand that. And then Ms. Burke, I mean, are you suggesting that the acquiring of either a conservation easement or of a compensatory wildlife habitat is not an appropriate way to mitigate impacts?
No, I wasn't saying that. I think that would be probably very appropriate on that list of potential projects. I just thought it was interesting that the compensatory mitigation fee, which, as I understand it, is to go to CPW to potentially carry out any number of mitigation projects. The fee itself seems to be focusing on conservation easement values. So it's the dollar amount connection, as opposed to, for example, some way to assess the actual wildlife value of the per acre, or CPW had started with what it costs them to do short-term mitigation, but then that leads to the point that Mr. Hurt was just talking about, which is, yeah, it's not expensive to go out that first time and put some soil amendments down and reseed, but that usually doesn't do it. It takes much more than that. So I'm just saying, conceptually, the cost of a conservation easement seems like an odd way to measure a compensatory mitigation fee that could go to all kinds of directions. But yes, I would think that purchasing conservation easement rights over property, or doing mitigating some kind of disturbed habitat to bring it back up to higher quality, those would be appropriate projects to be on that list. Does that answer the question?
Sure. I mean, I think one of the things that's being considered here as far as determining compensatory mitigation values is, what does it take to properly, what is the dollar amount that it takes to properly mitigate the impacts of a particular well pad location? And if you were to acquire property or a conservation easement as substitute habitat for this particular location, what may it take to be able to do that? And I think that's what's being considered as a long-term solution, or a compensatory mitigation solution, versus the short-term being more perhaps some of these mitigation projects like Mr. Hurt was talking about.
Was that a question? It's very complicated, and honestly, I don't envy you, because it is complicated to figure out the proper way to price any of these things. And that's, I think, one of the commissioners had asked, I believe it was yesterday, about, what is our actual goal? And I guess that would be my question. Are we replacing habitat, to make up for habitat that it has been impacted, or are we fixing the specific impacts that have occurred? Are we trying to find an equivalency? It's complicated, but it seems to me that the place that you're heading with CPW's advice is probably fine. I just wanted you to look further into this concept of those actual dollar amounts in their tables.
Thank you very much.
Other questions from commissioners? Ms. Burke, you had indicated the 502C variance was the preferred approach from your group's perspective. Is that with all 5 of the criteria, or have you had any thoughts about removing 1 or 2 of those criteria?
My initial inclination was to leave all the criteria and let a variance be a variance. I think Commissioner Njapa asked the question, I believe, or maybe it was Commissioner McGowan and Ms. Wazelenki answered about, it is a different question that there may be actually more protective to be within the buffer than without, and therefore, however, I think that rather than complicating matters, you could leave the criteria as they are. It's just the answer to that particular one in that case would be very simple. Say, we consulted with CPW, which potentially it's feasible to be outside, but in this case, it's more protective, and be able to meet that criteria in that way rather than parsing it and chopping it and which rule and which criterion and making it more complicated. That's my fairly simplistic view on that.
All right, thanks. I'm not seeing other questions, so thank you for your closing statement today and for your participation. It is very much appreciated. We will zoom away Mr. Hurt and Ms. Burke and bring to the table the wildlife hunting and angling groups and citizen groups panel.
Good afternoon. I should be with you now. Can you hear me?
We can.
Terrific. Good afternoon. I'm Bob Randall for the Wildlife Hunting and Angling Groups. Just want to thank you for your continued thoughtful engagement here on the 1200 series. I'm going to touch on the topics addressed during discussions yesterday, plus just a couple of others. First, I'll touch on waivers from the buffer set out in proposed Rule 1202C. As I understand the state of play, an operator proposing to locate a new oil and gas development plan within any of the buffers in Rule 1202C would be required to obtain a variance from the Commission in a public hearing on their permit, full stop. The question, as I understand it, is whether the operator may seek CPW's explicit waiver of such a buffer as a result of consultation. This waiver would demonstrate to the commissioners at what CPW thought about the request, even if the habitat at issue was not going to be avoided as called for in Rule 1202C, and whether wildlife would be protected through measures to minimize or mitigate the impacts, but it would still be subject to a hearing before the Commission on the OGDP. I think that generally the commissioners would be wise to consider CPW's position on that question, but I don't know that it's necessary to be too hung up on whether that position is called a waiver or simply a recommendation, because as Commissioner Messner noted earlier today, it's still a decision for the Commission through a hearing on the OGDP. As to the question of what an operator must show in a Commission hearing on the requested variance, it appears that you all may be considering whether to waive the requirement that an operator show that it's made a good faith effort to comply or is unable to comply with the specific requirements, and that the requested variance is necessary to avoid undue hardship. Those are in Rule 502C, sections 1 and 3. On the first, it seems to me that when you're talking about an NSO buffer, the good faith effort to comply would happen as part of the alternative location analysis, and that the operator really should be required to demonstrate why they can't select an alternative that complies with the buffer. That, after all, is the entire purpose of the analysis of alternatives, to assess the impacts and the viability of different alternatives. Removal of this criteria would justify a variance simply based on the operator's preference, but wildlife simply don't get to state their preference when selecting habitat. On the second point, I suspect that how high the bar is to demonstrate undue hardship in the context of 1202C would probably depend on the measures that the operator is seeking to excuse or to avoid, the habitat that's at issue, and the likely negative impacts to the species. But there's no basis to require this showing for a waiver from public health, safety, and welfare requirements, and then to excuse it entirely for a waiver of wildlife rules. We submit that the showing for a variance from a wildlife rule should be the same as that required for rules to address mechanical integrity, prevention of waste, or protection of other resources, including public health, safety, welfare, or the environment. And that to do otherwise would say that wildlife is less worthy of protection than other resources that the Commission is directed to protect. Second, on the question of buffers for aquatic high priority habitats. CPW has made clear that they recommend a 500-foot buffer for aquatic high priority habitats because avoiding these areas is necessary to protect both fish and other aquatic life and other wildlife species that use these corridors for forage, for transit, and for respite, including birds, amphibians, reptiles, small game, and big game. As to the three options discussed on Wednesday, we strongly prefer the option of adopting the staff's proposed revisions as is, with 500-foot buffers for all aquatic high priority habitat. These buffers have been deemed to be necessary to protect the most sensitive wildlife species and habitats in Colorado, and they reflect the recommendations from experts at CPW and from COGCC that avoidance of areas within 500 feet is necessary to protect these high priority habitats. For the same reasons, we strongly oppose reducing the buffers for sportfish management waters and for native species conservation waters from the 500 feet proposed by COGCC and CPW to 300 feet. Again, CPW has recommended that operators avoid development in these areas in order to protect the species. And other than complaints that the acreage covered by these areas is too large, we haven't heard a credible basis for reducing these buffers across the board. As to the possibility of a third option, which I'll describe as a hard buffer at 500 feet for gold medal and cutthroat trout waters, and then a soft buffer that could be reduced through a waiver to 300 feet for sportfish and native fish waters. This could be workable if any reduction in the buffer for sportfish and native species waters is heard in a public commission hearing, and if the spill prevention measures applicable to the intermediate zone in Rule 411 be required when drilling within that original 500-foot buffer. There was a lot of discussion about the state's highest value and highest priority fish streams. Those are gold medal waters and cutthroat trout waters. Commissioners heard testimony from CPW that these represent about 3% of the streams in the state. And reviewing the map that CPW provided, there isn't a significant overlap between these areas and existing oil and gas wells. For these reasons, we urge you to require the spill prevention measures from Rule 411 when drilling within 1,000 feet of gold medal and cutthroat trout waters. These are the state's most valuable fisheries and highest priority waters, and they deserve protection beyond the minimum afforded the other streams. And specifically, they deserve protection from the impact of spills occurring at that 501st foot. We've previously urged that all of these measures in Rule 411 be required when drilling within 1,500 feet of all high priority aquatic habitats, but I'm here today to really focus that request and to do so and to require those within 1,000 feet of the best, and would just submit that what's good for drinking water is good for the most important 3% streams in Colorado.
You're
Chair
over time,
Robbins?
so thank you.
Okay, I was under the impression I'd been ceded time from another party. If Ms. Larson didn't receive that email, I'll stop there.
Ms. Larson?
I apologize, Mr. Rendell. Yes, I was looking at the wrong entry, so you do have 10 minutes. Apologies.
So keep going, Mr. Randall, and we apologize for taking you outside of your well-done presentation.
Let's give him the director's privilege right now, too. So.
Thank you, Director Gibbs, and thank you, Chair Robbins. I'll continue. I was about to turn to migration corridors, so that was a fine transition to do that. So again, on migration corridors, in his executive order issued last August, Governor Polis declared that conservation of big game migration corridors was essential to Colorado's outdoor recreation economy and landscape heritage. That order also stated that intact seasonal habitats and the migratory routes that connected them were vital to ensuring that Colorado's big game populations continue to thrive. And it concluded that it was timely for the state to conserve our migrating big game populations and their habitats. I appreciate the Commissioner's recognition during early deliberations that avoidance is often the best way to protect migration corridors because of the difficulty in mitigating impacts once they've occurred. You simply can't compensate through projects or through payment for the loss of an area that is biologically preferred and that has been used for millennia. We also recognize that the migration corridors are often large swaths on the map, and that including them all in Rule 1202C would subject this commission to many, many requests for variance in all likelihood. Given all of this, and consistent with our request that you focus on protecting the highest value habitats for aquatic species, I'm here again to urge you to move the most important areas of migration corridors from the consult mitigate regime of 1202D into the NSO buffer regime of Rule 1202C. Again, we're talking about bottlenecks or pinch points caused by topography or stopover areas where animals spend more time during their migration. These will be discrete areas that are much smaller than the migration corridors themselves, and they're vitally important to the long-term viability of our big game herds, and they can't be replaced once damaged. I recognize that CPW hasn't comprehensively identified these areas, sufficient to propose them for inclusion in the maps that will go into effect on January 15th. And we would request that the commission include language in the statement of basis and purpose, stating that avoidance of these areas is necessary to protect these species, but acknowledging that the maps don't yet exist to include these areas, and requesting that CPW bring forward any information it has on stopover areas, bottlenecks, or pinch points for the map update in 2022, and then on a rolling basis going forward. The focus of these requests that I'm making today really reflect our belief that you should include the state's most sensitive areas for both riparian species and for big game in Rule 1202C as avoidance areas. Both this request on a subset of migration corridors and our request to require spill prevention measures within 1,000 feet of gold medal and cutthroat trout streams are focused on protecting the highest value habitats for terrestrial and aquatic wildlife. They are simply irreplaceable. Given the significance to maintaining healthy fish and wildlife populations, and given that they're narrowly tailored to the highest value habitats, they are both reasonable and necessary to protect wildlife resources. So with that, thank you for your time today, for your engagement throughout this marathon rulemaking, and for your service to the people of Colorado. I am happy to take any questions.
Thank you, Mr. Randall. To your last point about the pinch points and the stopovers and your acknowledgement that CPW does not have them mapped, and I know in discussions that we've had with CPW, there is some information they're developing with CDOT for particular crossings, et cetera. But I think I hear my lawyers telling me that there's a reluctance on our part to adopt a rule that isn't consistent with the map and will come into play in another year or so. And I may be misinterpreting my lawyers, but can you speak to that issue and how you would formulate that rule that would be consistent with something that AAG Davenport, who just appeared, would be comfortable with?
I can try, Mr. Chair, and invite Mr. Davenport obviously to weigh in. So I heard AAG Davenport addressing the sort of perils of adopting a rule of prospective applicability. And I understand that. I don't think that's what we're asking for here. While, should you adopt the language that we're urging, it wouldn't have the practical effect of requiring operators to avoid these areas when the rules go into effect. It's more a matter of when compliance with the rule would be required. At the highest level, the Commission is directed in Senate Bill 181 to adopt rules that protect wildlife resources. If, in the Commission's judgment, it's necessary to avoid pinch points in order to meet that standard, then I would submit you should adopt rules that require operators to avoid them. And if compliance with that rule is delayed due to the need to complete mapping, then I just don't see that that raises an APA problem. It doesn't incorporate a future document by reference. It doesn't subject operators locating sites in what might eventually be a pinch point to enforcement. The statement of basis and purpose would acknowledge that compliance isn't required until the maps are adopted. And so it just doesn't operate to the disadvantage of the regulated industry. This isn't a case where the Commission would be proposing to hold operators to a standard based on maps that don't yet exist. Again, I could see that creating problems under the APA by incorporating a prospective rule, but I think that what we have here is really just the opposite. So that's my read on it. Again, happy to engage in a discussion.
I see lots of AAGs appearing on my screen. Does anyone want to speak to this?
Thank you, Mr. Chair. This is Assistant Attorney General Kyle Davenport. I did see Commissioner Najaba raise her hand. I'm happy to defer, of course, if she's got a question. That okay. What I want to, I think, start out is remind the commissioners the way the current rule is drafted is the maps are adopted as a rule. And the APA does require that whenever the commission changes its rules, it must follow the rulemaking process, which in essence is notice and an opportunity for folks to give their input on that rule. As I understand Mr. Randall's proposal, and I would encourage him to correct me if I misunderstand his proposal, that the rule would essentially require compliance with a map that is then adopted in the future by the commission as a rule. Is that correct, Mr. Randall?
Not exactly. So again, the rule is setting out areas that are to be avoided, and the requirement to avoid those areas is tied to a map. If an area isn't reflected on the map, then avoidance of those areas is not yet required. And so, you know, I recognize the commission is headed towards updating maps via rule through notice and comment and everything else. And so it is after that process, should CPW come forward with data demonstrating the existence of these areas and the location of them, that they would go into effect and that operators would be required to, you know, to comply with them. Just as today, if there is severe winter range, for example, that isn't reflected on the map that an operator is proposing a pad in, there's no requirement to consult with CPW. There's no sort of trigger or, you know, there's no mechanism to force that. If there is a, one of the species or habitats listed in 1202C, a nest of some sort that is not reflected on CPW's map, then again, I don't think there's a requirement to avoid those. I don't know that there would be an enforcement mechanism if an operator were to locate a site there. When the map is updated to include those sites or that habitat, then it would. And that's, I guess, what I'm proposing for pinch points and stopover areas.
Okay, thank you, Mr. Randall. I appreciate you clarifying that. Commissioners, my concern remains that if the commission wants to adopt maps or data that CPW has as a rule that would require procedures for any area that CPW has identified as high priority habitat or migration corridors or anything, that needs to be a rule. And in order to make that a rule that is enforceable, the commission needs to adopt it through a rulemaking procedure, which would, in my view, preclude what Mr. Randall is proposing is sort of a rule that allows CPW to, when their data changes, to effectively change the commission's rules to require certain procedures in areas where they weren't required prior to that. And happy to answer questions if that's unclear, or I know that staff's counsel is also present. So if staff has a different perspective, then AAG Stafford is here as well.
I think I see Commissioner Nanjapa who would like to weigh in on the discussion.
Thank you, Mr. Chair. And more just to clarify what I thought I heard and I thought was an interesting idea is more about language in the SBP that recognizes the value of these areas and an intent to include this in the next map update. With my understanding that we are updating the maps as part of this rulemaking to what is currently available, and that the notice for the next update wouldn't be until January 15th, 2022. So if I'm understanding correctly, I mean, is that a way that we could do this? And I look to AAGs, both AAGs on this one. You know, could we just have a statement sort of recognizing this, that, you know, this isn't currently mapped, but that we would like to see that included. And of course, I'd want to ask this of CPW if this is even, you know, possible, but is that one way we could sort of handle the acknowledgement of the importance of these habitats and the need to get them mapped in the next update?
Mr. Chair?
Yeah, AAG Davenport.
Thank you. Commissioner Najapa, certainly the commission can express its preference for what it would like to see in maps or express its position or intent that it believes certain habitats are important things to consider and it intends to consider those in the future. The SBP, the purpose of that document is to state the commission's intent and purpose in adopting rules, and it in itself is not a rule. And so what the statements in the SBP would not have the effect of rule, but they are certainly there for the commission to express its intent and purpose and meaning, and the purposes that you just stated, in my view, would be appropriate for the SBP.
Commissioner McGowan, I'm sorry, Commissioner Nanjiapa, did you have a follow-up?
Sorry, just a really quick follow-up for Mr. Randall. Is there any risk that you can perceive if these were mapped and publicly available? For example, I know for certain other sensitive species, you know, there's concerns about making those locations available, you know, because it could increase the threat on those species.
Mr. Randall.
Thank you. And Commissioner Nanjiapa, that's a good question. You know, in as much as these would reflect areas of concentration of animals that could subject them to increased attention from, you know, hunters, I suppose. I don't know how CPW would respond to that. I certainly recognize the kind of peril from putting a spotlight on a sensitive species or in a sensitive area. You know, that could have at some level a population level impact on the species. It would not damage the habitat, but it might impact individual members of a herd, for example.
Commissioner McGowan, I think I saw your hand next.
Thank you, Mr. Chair. So I'm sorry, I'm not trying to beat a dead horse, but I'm trying to understand the distinction between, so for example, right now we have rules around different types of stream types and habitat types, and there will be a map that we adopt next year related to those habitats that we identified in the rules. That map is kind of a living document, and a habitat that doesn't exist right now in next year's map might exist the following year that we will adopt, but we've created this general definition of what we want mapped and a buffer around it. So I guess I don't understand why it would be different than if we identified an area that needs to have a buffer, and then when it gets mapped, it gets put into a map that we adopt. And then the rule right now would say, for example, we would add to 1202C buffers. I think this is what Mr. Randall's asking for. Bottlenecks and pinch points for big game. And as it gets mapped, we as a commission, when CPW comes to us on an annual basis with their map, that map gets adopted, and now that habitat is identified in the map. But to me, it's no different than something that doesn't exist. If we find a new lek habitat, we've identified lek habitats as a buffer area and a sensitive area. And if a new one comes along the following year, it gets added to the map. So I guess I need that explained to me why that's different.
Mr. Randall, do you want to speak to that, or AAG Davenport? Not sure which direction this question was going. Mr. Davenport?
I'm happy to defer to whoever Commissioner McGowan was directing that question.
I was aiming that to you, AAG Davenport, since, sorry, so hot spots on you.
No reason to apologize. So the first point, I'd like to address the first point that you made, that map is a living document. That map is a living document for CPW. Once the commission adopts it and puts it into its rules as an appendix and makes it part of its definition of high priority habitat, That map isn't a living document for the COGCC. It becomes frozen in time until the commission adopts the new map as a rule and part of its definition of high priority habitat. So certainly CPW may amend its map at any time, and the commission could then conduct a rulemaking to adopt that map, in which case it becomes part of the definition of high priority habitat and it becomes a rule. But for our purposes in adopting the map as a rule, it is no longer a living document. It's frozen in time, as is the case with any standard guideline or rule, any other standard guideline or rule that the commission has adopted through incorporation by reference in any other sections of its rules in this rulemaking. Does that answer your question?
No, sorry, Mr. Chair.
Go ahead, please.
Sorry. So I guess, nope, I understand that. What I'm saying is we have LEC habitat identified in 120C, 1202C, in the 1200 series. And it is related to maps that CPW is going to present to the commission, and we will adopt a map, and that for, let's say it's annually. That map then we work off and the operators work off for a year. And let's say the following year, new LEC habitat is identified. It didn't exist before, but the LEC area is identified in the rule, attached to a map that will change, let's say annually, based on commission adoption. And every year, as things are added or subtracted, they will then be reflected in the new map that gets adopted. So understanding that LEC habitat, for example, this year, well, maybe it's 8 acres, and the next year it's 10 acres or 6 acres. That's the new acreage, and that's the new map. The LEC buffers is what we've adopted to protect. So why would that be different if we then moved, and sorry, I'm not a lawyer, so I could be totally off here. If we put big game bottlenecks and pinch points into the rules, we know that they don't exist yet, but next year's map might, and then that gets put into next year's map, and it is the map that we work off for a year. I understand that it's frozen, but I guess I don't see the distinction between something that these other kinds of buffer areas that we have put into the rules, which will change over time, but be frozen while we adopt them and it's in the rule. So I hope I'm making myself understood. I'm not sure that I am.
AG Davenport.
Thank you, Commissioner McGowan and Mr. Chair. So one of the things I'm a little bit concerned about in providing responses, I'm wondering if we're getting a little bit beyond my area of expertise in how these maps work exactly. And I'm wondering if it's possible at some point to, if we can't get CPW in the meeting now, we can get them in a little bit later and revisit this.
That's fair. I guess I would ask this dumb question. Do pinch points and stopovers exist if they're not mapped? Mr. Randall?
I believe that they do. The maps are just reflecting the fact of where animals during their migration spend more time, or go from crossing a large area to crossing a small area. And again, some of that's due to topography, that they will go through a narrow pass versus a where it exists versus a broader area. So that might be a pinch point. Or because of the value of forage, or the cover from predators or some other thing, it's a place that they just spend more time during their migration. And so, again, these areas, the whole point is to avoid them. Just taking a step back, a location in some of these areas would preclude the activities that animals use them for during their migration. I guess that's kind of the ultimate point. So yes, they exist, even if they're not mapped. I think that Commissioner McGowan has described the circumstance that that I foresee, and that is, if these are, the rule would go into effect, but just as if there's a sage grouse lek, or as I look on the list of habitats in 1202C, if there was a piping plover production area that wasn't mapped and an operator wanted to locate a pad there, they could presumably do so. until the map is updated to include that area, and then that area would be subject to the avoidance standard in 1202C. So I think that Commissioner McGowan, you are again describing how I view the function of adopting a rule that will only apply once those habitats are reflected on a map.
Commissioner McGowan.
Thank you, Mr. Chair. And I'm not sure I'm comfortable with playing dueling lawyers and making our lawyers uncomfortable. So I'm wondering if it, to Commissioner Nanjapa's idea, and I guess my idea would be a little bit different. We have all these working groups, and honestly, I can't remember what we've assigned to all of them. But maybe the ones that are working, the biological group maybe could work with, or maybe CPW is working on mapping, and then at some point they bring, maybe we can put a date in where CPW, if they feel comfortable, could make a presentation to the commission about pinch points and bottlenecks, and then the commission can make a decision about whether and how to add them to the 1202 series, the 1200 series. Can we, I don't know if we can do that.
Mr. Chair, if I may.
Yes, Ms. Stafford.
We would like to bring in Mr. Holst with CPW just to answer a couple of questions regarding Commissioner McGowan's suggestions on the maps related to pinch points.
Very good. Mr. Holtz, good afternoon.
Thank you, Mr. Chairman, Commissioners. Great discussion here. Appreciate the focus on these really important habitat of pinch points and stopover areas in migration corridors. So, we have had a pretty robust discussion as the rulemaking's gone on internally with our big game experts about this topic. And, I think there is consensus internally that we could identify some pinch points probably by the next map update. We do not currently have pinch points identified. We suspect we know where some are. It's really a matter of, internally, again, to try and keep our HBH kind of process robust, we have to kind of internally come up with the definition of exactly what a pinch point is in order to map it in sort of a quantitative way. But we could do that, by the next map update, a year from January. We just don't have that done now, and we couldn't really get that done, by the time for these rules to take effect. Just to be aware, there probably would not be a significant number identified, because we would only do it where we have a substantial amount of data for the herds that we intensively manage. But we could do that by the next map update. Stopovers are a different topic in this sort of discussion. They are, I think, would be much more difficult for us to try and address. I'm not sure that we have a good concept of how to address that right now, even in our most intensively managed herds. And so that's something that we wouldn't be able to do as easily. But at least for pinch points, we could certainly come up with something, if that's helpful.
Commissioner Messner.
Thank you, Mr. Chair, and thank you, Mr. Holst, for that. That was great. And I mean, this is a good conversation, because I think what it indicates is that this is an important topic. I do want to confirm a couple of things. So I'm going to ask a couple different questions here, but I had asked previously, and I think Mr. Holst, you were the one to provide the answer around stopovers and pinch points, and understanding that these are sensitive areas, and that during a pre-application consultation or an on-the-ground truthing, if there was determined to be, a stopover or a pinch point in that review, then the recommendation from CPW could certainly be to avoid that area, correct?
Mr. Holt.
Thank you, Mr. Chairman. Yes, Commissioner Messner, that is correct. We could definitely do that. I mean, it wouldn't provide the same level of sort of planning protection as a 1202C would.
Right.
I think that's where some of the stakeholders are going, but we could certainly do that. It'd be more of an ad hoc, just like we would raise, some of these other sort of site-specific issues.
Right. But I mean, here, as we're having on the record testimony, I think we are acknowledging that, and that's some sort of understanding, ad hoc understanding that these places are to be avoided and would be, and are sensitive areas for a reason. And the reason that we're not putting them immediately into a 1202 C categorization right now is because we don't have them mapped quite yet. But some combination between that acknowledgement here and additional clarity in the statement of basis and purpose around that same concept that we're intending to avoid these areas, and we'll update these maps as appropriate. And I'm brainstorming here, but it could be a stopgap solution until we actually have them mapped and then are able to place them in the rules. And so I don't know, Mr. Randall, what your thoughts on that would be. I understand that your first choice would certainly be what you're proposing and what Commissioner McGowan is suggesting here. But I mean, would that be something that would be palatable?
Mr. Randall.
Thank you, and thanks for the question, Commissioner Messner. I think that could work on a case-by-case basis. Again, I'm approaching this from a potentially overly legalistic view, which is that the commission has a mandate to protect wildlife, and that in order to do so for big game, avoidance of these biologically significant areas is necessary. And so that should be reflected in 1202C. So that's kind of the basis for the request. I certainly understand that on a, if a location is proposed in what is a mapped migration corridor, CPW comes in through its consultation and identifies the existence, based on local knowledge of a pinch point, for example, that they could recommend that the pad be located elsewhere. Or if it can't be, then recommend that it be denied. So I think that could function to protect these areas and these populations as a stopgap on a case-by-case basis. Again, I would make the case and have for doing so a little more holistically, but I understand what you're asking.
Sure. Okay, thank you.
Commissioner Gonzalez.
Thank you, Mr. Chair. I want to dive into the fun topic of variances and waivers. So, Mr. Randall, we kicked off this conversation with talking about the potential variance elements, the showing elements. Now, I don't know if I'm using that word right, but that are required of an applicant to make a showing of in an application for a variance. And I want to explore that a little bit, because I want to make sure I understood what you said, which was what I think is that there's going to be an alternative location analysis. So they're going to have selected one of those other locations or have the opportunity to select one of those other locations. So why do they even need a variance? And I think correct me if I'm wrong there.
Well, it's just a little different. And that is that the purpose of the alternative location analysis is to assess the impacts of a location and to choose the one that has the least impacts on wildlife, consistent with 181's mandate. So it's a substantive analysis to choose the most protective site. So that's my only quibble.
Thank you. No, then we are on the exact same page with that. And so in selecting the best site, with CPW's consultation, if everyone agrees the best site is within a buffer, how would an applicant show that they cannot comply with staying within that buffer?
Mr. Randall.
Yeah, I'm just going to look for the language on the showing that's required. Sorry. I think that could be excused as under the good faith effort to comply. And that good faith effort includes consultation with the state's wildlife experts. And if CPW were to say locating it here is better than locating it there outside of the buffer, then I think that would satisfy the showing. And again, I guess I would submit that whether or not an operator satisfies that showing is within the sole discretion of the commissioners in assessing the request for a variance. And so, on a case-by-case basis, the commission could excuse compliance with 502C1 if it felt like it needed to. So anyway, that's how I would respond to that.
And I think, and I get that. I mean, I get where we're trying to play with the language there of good faith effort to comply. When I think about good faith effort to comply, it's what did I do to comply? And if I can say, hey, the rule says I have to be outside of here, and I can comply, and I made a good faith effort to show that I can comply, but still my desire is to be inside, and we think the most protective spot is inside. I have a hard time understanding how and it's maybe not just us 5 commissioners, maybe commissioners 10 years from now that weren't a part of this, exhaustive conversation we're having on variances and waivers, who say, hey, this applicant has to make these 5 elements of showing, otherwise we're going to dismiss their variance. I don't understand how you can get over that hurdle when it explicitly says cannot comply or a good faith effort to comply. And when the alternative location demonstrates that there is an opportunity outside of that buffer, albeit potentially less protective, I have a hard time where we as a commission would say, the rules don't exactly apply the way they're written, and we're going to play with that language to alleviate the applicant of that element of showing. I'm having a real hard time with that, and I think you've heard me say that. So I don't know that, you're an attorney. If you don't think that we should leverage the language in the rule or apply the language of the rule as it's written in this scenario, then I have a hard time with it being applicable to the scenarios that we're describing.
Mr. Randall, would you like
Thank
to
you.
respond?
Sure. And my response is that, honestly, Commissioner Gonzalez, I think you're reading 502c1 as a constraint that has not been evidenced in past practice. The test of being good faith effort to comply or is unable to comply is not really the standard the commission might apply to an operator's request for a variance for the weight of the drilling mud that it might use, for example. Sometimes it just makes more sense in the operator's judgment as tested in a hearing and as confirmed by the commissioners, that it just makes more sense to use drilling mud of weight X versus drilling mud of weight Y, given the pressures in the formation. And so, the ability to comply or the good faith effort to comply, I think, is reflected in the application that an operator makes for the variance, saying this is why it makes more sense. This is, again, I think my sense is that you might be reading 502c1 with more rigidity than it's been applied in the past or that might be applied in the future. Because, sometimes it just makes more sense to do business in a different way on a case-specific basis.
And I suppose I'm just reading it as a new commissioner who's never done this job before. And so when I read it, I'm reading the rules as I read them. And I don't know how precedent from how the application has applied under previous commissions under the previous mission is going to be applied here. And that's why I'm kind of a stickler for the language that we're choosing to make sure that it's appropriate. Do you have and I imagine your answer is going to be the same for kind of the undue hardship component as well. Would there be a different answer that you would propose there, or is it just that, hey, practice has been different and we've seen that work in application under the past commission?
Mr. Randall?
Thank you. Again, my sense is that waivers for or variances from the requirements of the 1200 series should be subject to the same standards as variances from the requirements of other rules that are intended to protect other resources. The direction in Senate Bill 181 to protect public health, safety, welfare, the environment, and wildlife resources doesn't say that you can do so pursuant to a different standard for wildlife than you would for these other resources. So again, the basis of my argument is, look, if these are the standards for the commission deciding that a particular rule need not apply to a particular site, I'm just not sure the rationale for applying those differently or only requiring a showing on 3 elements versus 5 for wildlife. I'm just not sure that they're any less applicable here than they would be to some of these other operational requirements.
And thank you, Mr. Randall. I tend to agree with you that the variance should apply as a variance for the resources that it should apply to, right? And we've dictated that throughout the rules, and the variance standards haven't changed for other resources. However, because certain resources have some limitations in the way that they are defined, such as public water supply, that we have offered a different standard that wouldn't apply as a variance, such as the intermediate buffers that are offered for 411 and the public water supply system. So while I tend to agree with you that yeah, maybe the variance should stay the way the variance is written, I disagree that it can be applied in all instances for all resources, and I think we've tailored our rules accordingly, which is why I think it's appropriate in this instance and for this particular resource that we allow CPW, the stewards of wildlife in this state, to opine on the appropriateness of the habitat that is being protected, the resource that's being protected. So that's not a question, that's a statement, and you're welcome to respond to it.
Mr. Randall.
Thank you. So again, I agree that CPW's opinion as to whether or not a certain provision of the 1200 series should be required on a site-specific basis is information the commission should get, needs to get, and certainly should consider. Going back to kind of a consideration of should that be a waiver of the rule, or should it be an expression that goes into the commission's, an expression of sort of very informed judgment that the commission should take into account in a variance request in a hearing. That is where we maybe differ. And that is that, in my view, it seems a little incongruous for CPW to be able to waive a provision of this commission's rules. I think that if they think a buffer shouldn't apply or an operational requirement shouldn't apply, they could recommend a waiver to you all. And again, that could be considered in the commission's hearing on the matter. But again, I was really responding to the industry parties' formulation whereby, certain buffers could be waived by CPW rather than having that be simply a recommendation that's made to this commission.
One quick follow-up on that.
Yeah,
and I appreciate this dialogue, Mr. Randall. So when we talk about kind of the recommendation of a waiver, I mean, isn't that kind of what it is? They don't have ultimate say. It goes to the director if it's a waiver, it goes to the commission if it's a variance. So if it's a recommendation of a waiver, it's still a recommendation of a waiver that goes to the staff to decide on that recommendation. And then it goes to the commission to decide on the staff's recommendation on that recommendation. So I think it gets to the same place here is that we are relying on CPW to make a recommendation. It's not a waiver. They're not waiving our provisions. We're clear there at least?
We're clear there at least, you bet. I think, again, as I said in my closing, I think it's a little bit of a distinction without a difference. Maybe it's just what you call it, a waiver versus a recommendation, but I think we agree that the buck sort of stops with the five of you.
I appreciate the dialogue, Mr. Randall. Thank you.
Thank you very much.
Other questions for this witness? Seeing none, thank you, Mr. Randall.
Thank you for all of your time.
Has been very helpful to us, and we will excuse you as a witness who has been very helpful. Commissioners, it's right at 3 o'clock. We've been going for 2 hours. Do you want to take a 10-minute break, 15-minute break, and then start back up? Does that look okay? All right, let's return at 3:15.